Hello, good afternoon, and thank you once again for joining us on COVID and the Law. This is your legal light and help law in these trying times. Today, are you a tenant? And are you in difficulty or at the risk of being thrown out of your accommodation? Has your landlord increased your rent and you are unable to pay because you have suffered a salary cut or you have lost your job? The government's appeal to landlords is that they should be sensitive and sympathetic to tenants. What can we all do to help each other in this time? This is what we treat today on COVID and the Law. You're welcome back. So last week, we treated force majeure contracts at risk due to the pandemic, how to resolve these problems. These are our takeaways from last week. The terms of a contract must be respected due to the principle of sanctity of contracts, requiring parties to adhere to the terms of the contract in good faith. Express inclusions of force majeure provisions in contracts is imperative to ensure that event organizers survive disruptions in the performance of their contractual obligations. Unlike common law countries like the UK and Ghana, force majeure must not necessarily be expressly provided for in a contract to apply in civil law countries like Germany, France, and Italy. In the absence of a force majeure clause in a contract, it is necessary for event organizers to renegotiate the terms of the original contract by mutual agreements. Thank you. Now let's do our news round. The Minister of Works and Housing in April this year asked landlords not to use the circumstances around COVID-19 as an excuse to evict their tenants. The minister reminded all Ghanaians of the president's show of utmost care and generosity to citizens in these trying moments, urging landlords to extend similar generosity to their tenants. He was speaking at the Ministry of Information's press briefing update on COVID-19. But this has not stopped some house owners from demanding their rent, while some tenants cringe at the thought of their rent expiry. There is more in our news round.
Lizzie rents a one-bedroom apartment in Community 11 Tema. Before she became a freight forwarder, she was jobless for a whole year and couldn't pay her rent. Initially, she dreaded the thoughts of being evicted by her landlord. But as fate will have it, it turns out he's the one angel favoring her in this COVID era.
When I lost my job, he was very understanding. He didn't throw my things out. I owed him as I think about over a year rent, and he was very patient with me until I was able to pay any amounts that I had. I took it to him and then he accepted it. He encouraged me to not give up, and it's been quite a journey. And amazingly, when COVID-19 came, I mean, he's been more sweeter than before. It has never bothered me about rent. When are you going to make payments, even though I owe him a few months? He has never mentioned this.
Same cannot be said for Mavis, who lives at the extreme end of the same community. Her container room costs 70 Ghana cedis a month and is a few months away from exhausting her 2 years' rent advance. With 2 children and no job, she cringes at how she will renew her rent and cater for her 2 children.
You see, I'm a hairdresser, and because of COVID-19, I don't go to work with 2 kids. I don't go to work, and I don't know how I'll get the money for the rent again.
Okay.
So if the government or Minister of Housing have something doing about it, I think it will be better for us. They should reduce the monthly pay of the houses, or they should stop taking a house rent 1 year or 6 months grass. It will be better for us.
So lawyers, how should rent matters in this COVID pandemic be discussed?
What does the law say about eviction of tenants by landlords? Section 19 of the Rent Act 1973, Act 220, as amended by Rent Control Law 1986, PNDC Law 138, and Rent Control Amendment Law 1986, PNDC Law 163, gives us a clear understanding as to the behaviors that we should all exhibit. When your rent is in arrears for 1 month, you can be evicted. That's what the law says. A conduct which is a nuisance or annoyance or adjoining occupiers could be a good reason for your eviction. Using the premises that you have leased for immoral or illegal purposes. Giving a written notice to vacate the premises. The landlord also reasonably needs the premises for his own use or that of his family or any other person in his whole-time employment. And when we use the word haste, and we are gender sensitive, it means the landlady, where the lease has expired under Section 36 of the Act above and will become a statutory tenant when the tenancy is tied to an employment and the employment ceases. These are the scenarios that could bring about eviction. In all these circumstances, the law does not encourage self-help, but one's recourse is a district court or a court of competent jurisdiction. May I also remind you that a landlord may face criminal prosecution if he does any of the following to the tenant. A, fraud under Section 443 of the Contractual Act 1973 is occasion when the landlord falsifies title to the purported lease premises or refuses to divulge any encumbrance material to the title. A conviction could be a fine and an imprisonment not exceeding 2 years or both. B, rent advance exceeding 6 months could land you in jail of a maximum term of 2 years, a fine or both.
You're welcome back. This is COVID and the law, your legal light and help law in these trying times. And I welcome my guests before we go to the case of the day, which we will use as the standard to help you understand and resolve your issues regarding your relationship with your landlord or with your tenant. My guest this afternoon is Ms. Hanifa Yaya, and she's managing partner, Hay and Partners at Law. Hanifa, thank you very much for making time to join us.
You're welcome, sir.
Thank you. So she's here to assist all of you with your issues, and your questions are also welcome, as we always do. So now let's go to our case for the day.
My landlord is fully aware my salary has been reduced by 60% because my workload has been reduced as a result of a shift system my employer has introduced to enable us observe the COVID-19 protocols at the office. I told him we have been divided into 2 teams and each goes to work for about 2 weeks in a month. Now we report to work by 10 a.m. and close by 4 p.m. He has observed these changes, but he has asked me for rent advance. I should have paid when my time was up over a month ago. He gave me 1 month grace period to pay or he will give the place out. He has accepted 1 month rent, but now refusing to accept 1 more month rent, insisting the grace period is over. He wants 2 years advance, which he has increased by about 30%, even though he hasn't done anything new to the house. This time, he has added property rate to the rent. I can't get a loan because I took a huge amount in December 2019 and invested in my ongoing building project. I may be able to raise the advance in 6 months. My wife just delivered, and this rent advance pressure and threat of eviction is really worrying us. We had an issue once, and rent control didn't help much. Thank you.
You're welcome back. So this is a very difficult situation that our case of the day finds himself or herself in. Now, I believe that there are a number of you who may be in similar circumstance. So let's begin and getting some assistance around the questions of landlord and tenant. Now, in the case that we have just heard, he has lost 60% cut on his salary. By virtue of that, his rent has determined or the time for him to have renewed has occurred. But he doesn't have the money. So he pays for 1 month and pleads with the landlord. He agrees and takes 1 month's, rent. He says in 6 months he should be able to gather this money. This landlord is not ready to listen to him. And as we also heard from him, again, he's seeking 2 years advance, which we know is a normal thing. What first of all attracts your attention for some sort of help for our viewers?
Well, to begin with, we are dealing with landlord-tenant relationship, which is also contractual in nature. He doesn't tell us...
Contractual means they must have entered into a contract.
Yes.
So everybody would have some paper or document of sort.
Well, as you know, Samson, the law says that in land transactions, so in transactions relating to the lease of land, the transactions must be in writing, right? Except for those within 1 and 3 years. Okay. So for transactions in land, that's limited to 3 years. An oral contract is admissible. Okay. So I can agree with my landlord or tenant without actually putting things in paper. But you say the safest thing to do is to make sure we put things on paper. At all times, it is safe and in everybody's interest to put everything in writing, signed and witnessed, including all the terms, so that everybody knows where they stand at each time. So starting point, you're saying the relationship between the landlord and the tenant is governed or regulated by an agreement or a contract. It is a contract. It may either be in writing or not, but the law prefers that it is in writing. All right. Now, where it is not in writing, we know that there are some implied covenants within that regulates the relationship between landlord and tenant. The law is very flexible, is very favorable towards the tenant, because the law doesn't want a landlord to wake up in the middle of a rainstorm and throw a tenant's belongings out and sack them for whatever reason. So the problem we have doesn't say what the agreement is. For example, all he says is that his time was due.
Right.
Now, without the advantage of what the terms of the previous tenancy is, was it a 2-year tenancy that expired?
Yeah, that's my suspicion here.
2-year tenancy that expired. Now, at the point where the tenancy has expired, then the tenant becomes a statutory tenant.
Okay.
Now, which means that the landlord cannot take any action regarding the tenant without recourse to the court.
At the time when his tenancy had expired,
yes,
he had become a statutory tenant. And you said that means what?
That means that the landlord cannot evict or take any action against him without recourse to the court.
Okay.
Because the court law is very protective of a tenant. That you need to go to court to tell the court the reason for which you want your tenant to behave in one way or the other. Now, he also says that the landlord accepted 1 month's rent.
And it's instructive. The statutory tenant you mentioned here was mentioned by the minister himself. Yes. And he used that to urge the landlords not to treat the tenants anyhow.
Exactly.
Because there are sanctions you can suffer under the law.
Exactly.
Right. Okay, so please go on.
Exactly so. So if the 1 month rent that the landlord has taken, and then now he's saying that he doesn't want to take any more monthly payments until he gets the money in bulk.
Right.
It also feeds back into what their agreement has been. Was it paid 2 years in advance at the beginning of the term, 6 months into the term? What was the previous agreement? We don't have the advantage of that. But as you said, assuming it was a 2-year...
2-year, and he paid the 2 years in advance.
And he did pay the 2 years in advance. Well, the minister, as you also note, and as the law says, that you are not allowed to take rent for more than 6 months at a time.
Right.
And the law is very clear on this, and even has criminal sanctions for breach.
Okay.
However, like you said, it's the norm. Landlords want to rent their premises. Tenants are desperate for accommodation, so they agree to do 1 year, 2 years, 3 years, whatever they agree on. And as I said, it's a contract. So once they agree on it, then the parties are bound by it. But in this particular situation, we see a tenant who is really desperate and doesn't have money to pay the rent in advance. And so what we can advise is that the 6 years statutory requirement.
Before you get to that advice, you mentioned something that is very important to our viewers and many people across this country, that they continue to hear that landlords are not supposed to ask for rent advance in excess of 6 months.
Yes.
But we know that in this country, they either take 2 years or even more.
That is so.
And you say that is against the law. I would like us to just read that law before we proceed. Now, that is Section 25 of the Rent Act. It says, any person who, as a condition of the grant, you are granting the person tenancy, or renewal, or continuance of a tenancy, demands in the case of a monthly or shorter tenancy the payment in advance of more than a month's rent, or in the case of a tenancy exceeding 6 months, the payment in advance of more than 6 months' rent, shall be guilty of an offense, and shall, upon conviction by the appropriate rent magistrate, be liable to a fine not exceeding 100 pounds. I think that will now come to 100 penalty units. So that will be like 1,200 for offending the law.
Yes.
Okay. So that is very instructive to note. So you say, beyond that, what should we do if they are insisting and we need our places to put our heads?
Samson, that is why you have never in your legal practice heard anybody complaining or charging any landlord for taking. I have never heard any single case
Me
throughout
too.
our legal education and practice that any landlord has been successfully or even charged for taking rent advance
more than
in excess of the 6 months period.
Okay.
And which also feeds back to what I earlier said, that is a contract. If two parties contract, even though they contract out of the law, because if the law says take 6 months and you contract beyond that, then it appears that both parties have
engaged in an illegality.
Exactly.
Okay.
And therefore, not one of them will be heard to complain about it.
All right.
So that is why it's quiet.
Okay.
We grumble about it every day. They say 3 years rent advance, 2 years, 1 year. I don't have it. But nobody goes to court to enforce anything.
Okay.
You don't want it, you walk away. The landlord will get the next person who is eager for a place to lay their heads or to do their business.
Elsewhere, they take the rent like by the month.
That is so.
Why can't we do this?
Something.
And why is the state not assisting particularly the poor? Because they can't afford even 1 year rent, even the 6 months. It's even more for too much for some people.
It is true.
So why can't the state enforce this?
The state has put this law in place. You see how clear it is. And if you notice, that law came about because of the existing circumstances at the time. Which law came to cure this mischief? Okay. So the law is very clear and has even given criminal sanction.
Exactly.
Nobody fears, everybody fears criminal prosecution and sanction. Nobody wants to go to jail for anything. Right. If you notice, this is ordinarily a civil matter, but the law has given a criminal sanction for its breach. But still, nobody has gone to court.
So it appears, like you said, and I don't want us to belabor this point, but you may have heard it too often. You have not been pointed to what specific law and what sanctions are available. That's why we are taking the time to educate you on it. So it appears because landlord is asking for more than 6 months, and I also need the premises, I can't complain. Because if I do, and I'm looking for a place where I'll be asked to pay less than 6 months or not more than 6 months, I may never get. Yes. So all the people are not complaining. Because nobody is complaining, nobody is being taken to court and punished as a landlord for charging more than 6 months.
Something people are complaining, but they are not going to the appropriate quarters. Okay. So you and I would have heard a million times how people complain about exorbitant rents, and even the advance beyond the statutory limit. Okay. But how can the state assist? If you don't go to the police and say, this is my problem, if you don't go to the court and tell the judge, this is my problem, how will the state assist? Right. Because the law is there to protect you. The state has done its bit. The courts are there, the police is there to protect you. All you need to do is to go to the appropriate quarters and make your case. Yeah, the other part of that is that once you make a report and your landlord is picked up, you don't want to come there and live with your landlord anymore. So you move on. Okay, so go on. You were saying about what the terms of the contract they have. Yes. So if the terms were that pay 2 years, and both had signed, then it becomes what I just said, that the two of them have contracted outside of the law, and that they are both going to be liable for that breach. Okay. Now, if that is not the case, so let's say that the previous one was signed for 2 years, it has expired. Right. It appears that the parties are now negotiating or talking about what the next term will be. And the landlord says, I want 2 years, as usual. And tenant says, I don't have a job, I'm in crisis. Right. So then the situation then behoves on the tenant to say that even though you want 2 years, and even though I'm already on the premises, I cannot afford 2 years. The law says 6 months. Right. So I am going to, if you give me some time, because he's saying that as we speak, he doesn't have anything to pay, but he's looking around to get 6 months. So I'm going to, let's say in a week or two or in a month, be able to gather 6 months rent to pay you, because that is what the law says. Then the tenant would be acting within the law. Okay. And then now it will be up to the landlord to either comply or refuse. Okay. Now, if he refuses, then the tenant will have a cause of action against the landlord because he's going in breach of the law.
But as you suggested, the landlord will not have the power to remove the tenant from the place.
He will not.
The only way he can do that is by an order of the magistrate.
That is so.
Okay, we'll take a quick break. When we return, you will all join us via Zoom and the rest, and as we continue this discussion and to assist you. You're welcome back. This is Covered Under Law. This is your legal light and help law in these trying times. And my guest is Hanifa Yahya, who is managing partner at Hay and Partners at Law. Now, you can join us, but whilst you're joining us, we are continuing to expand what we are looking at, the solutions to assist you in this process. Who do we have joining us? Hello, Benjamin Ado. Hello, Benjamin. I can see the two of you, Benjamin and who? In tow. Okay, Benjamin and Pinto. Hello. Hello, Benjamin and Pinto. Okay, unfortunately, they cannot hear us. So you spoke about something that I need to, help us understand. That when we are writing the agreement or the contract, we must indicate the rent that the tenant must pay.
Yes.
It will also contain terms. You said terms, and the terms, you mentioned something, covenants.
Yes.
That each party must respect, and that each party will have to sign.
Yes.
What do you mean by the covenants?
So the covenants are the terms of the agreement. Now there are some basic covenants that you find in most tenancy agreements.
Okay.
But as I said, it's a contract, and it depends on what you are contracting to do.
Okay.
Some premises are furnished, for example. So the covenants within renting of premises which is furnished are different because you come with nothing.
Right.
Some are not. So the basic ones that you take empty apartments to furnish, live in, and then move out at the end of your term.
Okay.
Will be the first important covenant, of course, the rent, because it's not free. So you have to agree on the rent.
Okay.
You have to agree on the duration of the agreement.
Okay.
You have to agree on who pays what.
Okay.
If the tenancy is furnished, sometimes they will, based on agreement, the landlord will put in the water bill, electricity bill, what other utilities, telephone, in the rent, and say that it's all inclusive.
Okay. So what you're talking about, what you constitute that you lawyers call express covenants, and then you have the implied
covenants.
ones.
So the express covenants are the ones that are within the agreement. So you pay rent every 6 months or every 2 years.
Okay.
You pay utility bills, pay for garbage, pay for common area maintenance if it's an
We're waiting
apartment
for your
building.
calls and all for you to join us on Zoom. So just get in and let's have a conversation as we use this one to try to give you some solutions.
And then there are implied covenants. The implied covenants are contained within the Conveyancing Act, which says that even in the event that these covenants are not clearly stated within the tenancy or lease agreement, they still apply.
Okay, so we don't put them in the agreement, but according to law, we know that they exist and we must comply by them.
We may put them in or we may not. If we don't, it still
so
applies.
he mentioned that now the man is asking him to pay property rates.
Yes.
This is an implied covenant.
It is an implied covenant, which the parties can contract out of.
Okay.
So for example, like I mentioned with some special forms of tenancies where the place is probably rented and furnished and cleaned and all of that, you may not have the obligation to pay the rates.
Okay. Utilities,
services, garbage.
Yeah, that's waste.
Common area maintenance, electricity, telephone, internet.
Okay.
All of this may already be provided in the premises, and then you will come and use it.
And like we always say, most importantly, you were mentioning to me a while ago, quiet enjoyment.
Quiet enjoyment.
It's an implied covenant.
Because all the covenants I'm mentioning are covenants of the tenant.
Okay.
So the tenant will pay. The tenants will do this, will do this, will do that. What does the landlord do?
Okay.
So the landlord's covenant is that after the tenant has done all that is required, then the landlord must also allow the tenant to have quiet enjoyment.
You don't disturb your tenant.
You don't disturb your tenant.
Okay.
You don't go knocking in the middle of the night and say, I want to come and inspect the premises.
Okay.
Even though the landlord may have the right to inspect, inspection is stated to be done at certain times as convenient for both parties.
All right. So join us, then let's have a conversation. Those guys who came in earlier, Pinto, and you can get back on Zoom, and you can also get us, I think, on phone as well. And then Lawyer Hanifa will take your questions and give you some answers. She had mentioned that once, and you heard the minister also mention it, once your tenancy period has expired, and you are still living in the apartment or premises, you haven't moved, because of certain circumstances, you have not been able to leave the place, you become what he says, according to law, is statutory tenant. So as she says, the tenancy relationship is regulated by your contract. But beyond your contract, we also have the Rent Act, we have the conveyancing law, we have the regulations as well. Yeah, who is on the line? Okay, hi, Benjamin. Benjamin joining us by Zoom. Yes, Benjamin, let's hear you.
Okay, sure. I have basically two questions to ask the position of the law on those situations.
Quickly.
Firstly, I think a friend signed a tenancy agreement with a landlord just before schools were closed. He's a college student, and so he's finding out whether his tenancy will read before he gets into the building, or that would read after the schools have been reopened.
Thank you. Next question.
That's the first one. The next question has to do with an organization has entered into a tenancy agreement with a landlord that 3 months before the expiration of the tenancy agreement, the organization is supposed to notify the landlord as to whether they would continue to rent the place or not. But the 3 months deadline ended in April, when there was actually a lockdown. And so the organization couldn't notify the landlord because of the lockdown imposed. And so we are finding out whether the landlord has the right to, rent off the building, or still wait on the organization to give the notice to the landlord before he can do so.
Okay. Did you hear him clearly on the second question?
Yes, I did.
All right. Thank you very much for joining us. And as far as the first one is concerned, I suppose that they have been following us and they have become aware of the general principles of frustration in contract.
Yes.
But frustration, does it apply strictly in the matters of rent?
It does. It is a contract. And as we are in abnormal times, our lives have turned upside down. Everything is not the way we know it to be. In normal times, like I said, the covenants will include the rent and the start date and the end date. Now, once you have signed on to that, then it means that, and paid, then it means that the premises is yours to enjoy until the term ends. Now, if you don't use the premises and then the term ends, should the landlord suffer for your not usage of same? I do not think so. However, because we are in abnormal times, and the president has made an appeal for people, landlords, to be considerate and all of that, it's possible. It's a moral appeal. It's not backed by law.
Yeah.
It's merely a moral appeal that once you know that the premises have not been occupied, hasn't been enjoyed, are you able to come to some sort of a concession to say that, okay, I know that for 3 months now, schools are down, you're a student, you probably needed a place for
But the landlord is not obliged.
He is not obliged.
And as we may be aware through some of the decisions of the court, the question of frustration, unless you have properly catered for it, will not apply in this particular circumstance.
No, not at all.
Okay.
That's what I'm saying. It's merely a moral appeal.
All right. All right. So let's wait for the second one, but let's take this other person who is joining us. Hello, hi, Pinto.
Yes, Samson.
Hi, Pinto.
Yeah, I can hear you. Please, can you hear me?
Go ahead.
Please, I have a couple of legal questions concerning.
Yeah, at least ask one or two quickly.
We are not in normal terms. Should I do 2 or 3 for the meantime?
Just do about 2 quickly and go. Yeah.
Hello?
Start. Let's go.
Okay. So I just want to ask what are the options available to a landlord who intends to recover possessions of a rented property that the rent expired during the pandemic, but the tenant is refusing to vacate the premises? That is the first question.
Thank you.
And
second
I
question.
Just also want to those rent advance, or those whose rent advance expired during the COVID period, I want to ask whether they can resort to monthly rent instead of the usual 1 or 2 years.
All right, thank you. So let's get to do this. But I suppose if you have been following through up to this point, some of the questions have actually been answered. Yes. Right. Yes. But still, let's attempt.
So the second question from the previous...
right.
He talked about the notice to renew. Now, it's one of the covenants in standard tenancy agreement that if before your tenancy expires, you should give notice whether you want to renew or not. This is fair for both parties. Yeah. For the landlord who would start to look for new tenants to take them.
Normally standard, how many months
for
do they
give? For 1 year tenancies, it's 1 month.
Okay.
But I know that even when you go to court and you are giving a recovery of possession, they will usually still give about 3 months to the tenant to find accommodation. So, you know.
I know of a circumstance where somebody was giving actually about 6 months to be able to find an alternative accommodation before they move.
Yes.
And then they were asked to pay the rent according to what they were paying originally, just as it happens to the statutory tenant you mentioned.
Yes.
Once it expires and you are not able to move, you remain as a statutory tenant and you'll be paying according to what was already agreed.
Yes.
Okay, so let's go on.
So this notice is also part of the covenants to say that give me 1 month notice, either you want to renew or not to renew.
Right.
Now he is saying that because of the pandemic, the notice has not been given. Now the question is, are the tenants still in occupation? If the tenants are in occupation, the 3 months notice period has expired, the tenancy itself has expired, the notice has not come in, then they have become statutory tenants.
Okay.
Because without the notice, it is assumed that the person does not intend to renew.
Okay.
So if the premises is empty and doesn't contain the belongings of the tenant, then as a statutory tenant, the rights of the tenant prevails. So the landlord will need to go to the court to get an order to recover
evict
possession.
Them.
Yes.
Okay. And don't say because you're hearing this of a statutory tenant, it means you can behave anyhow and stay forever. It doesn't happen, because you will be evicted eventually if you don't also play in good faith. And in fact, the landlord has also a right of what is known as distress to recover arrears and to get possession as well.
That is so. And I think this is what happened in the case of Jato and Pipim, I think. That the tenant was late, always late in paying the rent. So the landlord instituted legal proceedings to evict him. Then when the proceedings started, he ran to the court, he paid the rent. And his lawyer went to court to say that they had paid the rent, and they paid the rent arrears and left the mean profits that the plaintiff requested for as part of his reliefs. And then the lawyer for the tenants argued that, well, once they have already paid the rent, then the action should stop. And the judge said no. At the time of the inception of the action, the rights of the landlord had accrued. And therefore, the action doesn't abate merely because the rent has been paid. Okay. However, if the judge had a discretion to look at the circumstances and then can say that, okay, once the person has paid and will be willing to pay the mean profits and behave better in future, they may be allowed to stay.
Okay.
But in that particular case, they didn't allow the tenant to stay because the landlord said he was a chronic defaulter.
Is there a question we have not?
Now, yes, the recovery of possession, as we have already discussed, that once the tenancy has expired during the pandemic, the tenant is either pleading that I need some time to pay the rent, I want to stay, or is not saying anything. If the tenant is not saying anything and conversations have not worked, then the landlord will have the right to go to court because the tenant would have then become a statutory tenant. To go to court to recover the rent arrears. And then also the expired rent. He wanted to know that during the pandemic somebody's rent expired. What should happen? Pay the rent or not, the above applies.
In effect, nothing changes.
Nothing changes.
Your tenancy, your agreement remains what it is.
Everything remains the same.
The fact that there's a pandemic has not changed the terms. That's the point. But here, in line with what the government has sought to urge landlords, the plea is that let us all be sensitive to one another. All right. So let's take some of your comments that are coming in.
It doesn't fit into
all right.
a person's conduct. If you are a good tenant and there's trouble, your landlord knows that, oh, ordinarily my tenant is good. He never pays late. He always pays on time, or he gives me adequate notice to say I'll renew or won't renew. This must be because of the pandemic, and therefore I may have give him some grace period or be lenient. But if you always give your landlord hard time, not paying, you have to be dragged to pay, then the landlord becomes...
Yeah, the reason I'm stressing on the statutory tenant thing, because that principle of the law, according to Section 36 of the Rent Act, is that you acquire, the status of irremovability because your tenancy has expired and you have not left the place except that you don't have money to renew for the 2 months, 2 years that is being asked for. From month to month, then you'll be paying every month. If your landlord doesn't agree, then they have to go to court to remove you. The fact that you have acquired, the status of irremovability doesn't mean you should misbehave.
Not at all.
Because
and if the landlord refuses to take the monthly rent, you can go and pay it in court.
All right.
If he has instituted the action. Or you can go to a rent magistrate and then, say that this is my rent, my landlord is refusing. These days we have Momo. You can pay to the landlord via Momo so that you are looking clean.
So if you are paying, like our case of the day, he's paying the second month and he's refusing.
You can
so you can pay through Momo.
Or if he has the landlord's bank details.
Accounts.
Because they have been dealing prior, pay it to the bank account, hold your receipts. Because if he eventually drags you to court, you have to go to equity with clean hands.
All right.
To say that I've done my bit.
Thank you. All right. We'll take a quick break. We'll be right back. You're welcome back. This is COVID and the Law. This is your legal light and help law in these trying times. So let's take a question coming from Dennis Brown. He says, hello, sir. My issue is that a tenant entitled for 3 months to be evicted when his or her rent is due. If yes, is he supposed to pay for the 3 month stay? Okay, that has already been resolved. Once your period is due and you haven't paid, month by month, you pay the same money that you are supposed to pay. If it comes up to a difficulty and it goes to court, the court may give you 3 months to get ready and leave. That's the point that was made.
It doesn't mean it's rent-free.
It's not rent-free.
People think that the 3 months notice period is free. It's not. It's just to allow you to find alternative accommodation.
Right. Okay. Right. Are we picking any more questions from you?
And something.
Right. So, right. Yes.
It's a. We've always been talking about landlords, as if all of them are mean
bad
and are not understanding. At least I know about one landlord who has allowed the tenants some grace period rent-free because of the COVID. Because
Okay,
the landlady
rent-free, not just grace period.
Extended the rent. So let's say if the rent was expired in April, the landlady said, okay, let's extend it for you till June. Because we know that in the month of March,
okay, so
April,
you pay?
No.
Oh, you not pay?
No.
For a certain period?
Yes, March, April, May.
I think that's the appeal from the government.
Yes.
And elsewhere, some people are doing that.
Yes, so
okay.
at least
so a landlord spoke to me
yes.
Before we came for this show. A landlord spoke to me and he said, what I have done together with my wife is to tell our tenants that as and when you get the money to pay, come and pay. So they are not putting pressure on anybody.
That is important.
And they seem to be ready that when the tenants don't have the full amount, they will still even do something for them.
That gives a lot of relief to the tenants.
Okay. Right. So there are very good landlords out there. And of course, there are also some very difficult ones out there. So from everything else you have said, our case of the day, it is what the terms of the contract they have signed will do.
That is so.
However, in a circumstance, he should seek to plead with the landlord so that they renegotiate what the terms will be, paying the rate that he has been asked to. If the landlord not puts it in there, he can't say he will not pay. It is part of it. Okay.
But sometimes I think he mentions that the landlord lives on the premises with him.
Right.
So that makes the payment of the rate a bit troublesome.
Okay.
I am looking at a situation where you rent premises and you live in it entirely.
All right.
In that case, the rates will be coming to the tenant. The landlord may not even know when the rates have been submitted, a bill for the rates. And so in that sense, you know, it would make sense for the tenants to pay and claim it.
So if you're a landlord and you live in the premises with your tenants,
it becomes difficult to ask the tenants
you must partake in the payment.
It's only fair, isn't it? It's just like the water bill, the electricity bill. We know some landlords collect from everybody, and we know some in the end don't pay their own. Because what they distribute is enough to cover their own. But if not, if the meters are shared, then everybody must pay their usage of utilities and the rates.
Okay. Okay. All right. Thank you very much, Hanifa Yahya, managing partner of Hay and Partners at Law. And I'll just try this. If you haven't heard anything at all, you have been educated to know that, in fact, the law provides that you don't pay, or when a demand is made on you to pay rent advance for 2 years, that is against the law. That in the circumstances, you are to pay not more than 6 months. That's what you are supposed to pay, not more than 6 months. If someone is asking you to pay for 2 years, 1 year, that is against the law. However, we know it is observed in breach rather than in compliance. But that's the law, and you can be punished as a landlord if you did that and somebody didn't take your property but went to report. The police can arrest you and take you to court, and in the end, you will be fined to pay money for doing the wrong thing. Again, Hanifa has clarified for us that the terms of your relationship with your landlord as a tenant are in your agreement or contract, and that there are covenants in them. There are express covenants and there are implied covenants. And the implied covenants include, you don't put it in there, but they include that you must pay rates, you must pay for utilities, you must pay for waste, among other things. Nobody should come and do that for you. And also, the landlord, their major covenant that they are also to respect is that they must ensure that you live in the property peacefully, quiet enjoyment of the property. They shouldn't disturb you, and you must continue to live there. She has explained that if you lived and your tenancy expired, then from the time when it expired, if you have not been able to move, you cannot be ejected by the landlord by themselves. You become a statutory tenant. A statutory tenant acquires the status of irremovability generally. Irremovability, you can't be removed. But guess what? You can be removed by a court of law. So your landlord must go to court and have you evicted. Must go to a rent magistrate and have you evicted. When they go, they may give you 3 months to get ready to move out. And I said there was a circumstance, I got up to 6 months. It depends on your situation for the tenant to move out. But remember, that period is not rent-free. That's what she stressed. It's not rent-free. You will continue to pay the rent, but you pay the rent on the terms that have already expired. Stick to those terms. No any other new terms. If your landlord has to increase rent, among others, it must be by mutual negotiation. A question was asked whether or not you pay for the rent and you are not able to move in within the period, what happens? The issues of frustration, among others. Her point is clear. You must sit and renegotiate. Frustration may not apply to assist you in the circumstance. I hope I was good at trying to summarize some of the points that you made.
Yes.
All right, so thank you so very much. Hanifa Hayaya is managing partner at Hay and Partners at Law. I'm Samson Ladi Ayenini. I've been your host. We'll come your way again next week with COVID and the Law, your legal light and help law in these trying times. Send us your questions when you see our flyers and send us your emails and we'll help you to address them. Let's all be sensitive and sympathetic to each other within these trying times. Thank you very much.